Good morning, dear Sorainen webinar guests, ladies and gentlemen. Thank you very much for joining us this morning. This webinar is organized by Sorainen Life Sciences and Healthcare Sector Group, which includes legal experts from Estonia, Latvia, and Lithuania. My name is Ieva Andersone. I'm the co-head of our regional Life Sciences Sector Group. And as well, I'm currently also the country managing partner of Sorainen Latvian office. I'm very happy to be your host and moderator this morning in this webinar. This webinar is dedicated to help our clients and interested parties to navigate the legal landscape in healthcare and life sciences sector in Baltics. The topics we will cover today are quite a few and very interesting in my opinion, and are selected based on the most common inquiries we actually receive from you as our clients and from the members of the public. So these are topics with which we really have had a recent practical experience, not only reading the law, but also analyzing how we should apply it in practice to the most benefit of our clients and the public. So the topics will cover, of course, the current hot topics and the legal novelties in each of the Baltic countries. We will then look into the competition law application to the life science sector, which is always a very challenging and interesting question to consider. Then we will delve into the thing on which everyone is talking about these days, namely artificial intelligence, because there are also lots of ways how AI can be used and applied in the healthcare sector. Thereafter, we will look at the challenging battles in the pharmaceutical patent disputes and also discuss the product liability regulation. Now, a few practical points. Each presentation will take approximately 20 minutes, and we will do our best to keep to the planned schedule. We will try at the end of each presentation to cover also a few questions. Therefore, please feel free to interact with us and to post your questions or maybe comments or feedback in the right-hand top area of your screen. You should see the Q&A or questions and answers tab. So please feel free to use it and write your question there. We will do our best then to address it either at the end of each presentation or by posting and publishing directly a brief answer to your question in this section. Or we will also have, if we have some time left, a brief time at the very end of the webinar during the summary session when we can also cover a few questions. Also, you may take notes, of course, but you can also just relax and listen to the presentation because we will send over the slides to everyone who has registered for the webinar. And also the recording of the webinar will be available at Sorainen webpage and our YouTube channel. So don't worry if you have to jump out for a moment to take a call or probably be away for a part of the presentation. The recording will be available. Now I see that I have allocated 10 minutes to myself for the introduction and welcome address, but actually I feel that I have said already everything what is important for the beginning, and I'm eager myself also to listen to the presentations already. So let us turn to the first topic, which is the fresh legal news in Baltics, which will be delivered by our key life science sector experts in each country and also the local leaders at Sorainen for life science sector group. So let me introduce the speakers. This will be my Estonian colleague, Counsel from Estonia, Lise-Lotte Lääne. Then Latvian colleague, Senior Associate from Latvia, Marika Grunte. And last but not least, Senior Associate from Lithuania, Erika Žigute. Now, ladies, the floor is yours. Welcome.
Thank you. When we started with the preparing for the webinar, then it was quite difficult to pick up the topics for this particular presentation because the healthcare and life sciences sector is quite wide, and each and every entrepreneur in the field has its own legal issues, has its own very specific worries and concerns from that regard. So I had to take a pick, and I chose two topics. First, that what is very hot on the Estonian healthcare market in general at the moment is that we are entering into a very new era. The Patient Insurance Act will enter into force on 1st of November this year. So far in Estonia, we have had several questions from abroad that in Estonia, what kind of insurance the healthcare provider should have, and like what are the conditions, etc., etc. And then we say that, hey, in Estonia, we don't have it yet. This is not mandatory, although many healthcare providers they do it for themselves and for just mitigating the risks in general. But from 1st of November 2024, indeed, the Estonian healthcare providers who provide healthcare services under the licenses obtained from the Estonian authorities, they must also have the insurance to cover the possible mistakes or possible causes that have resulted in the bodily injury, health damage, or even death of a patient. And for the time being, there are many unclarities with regards to how this will be applied, the law. The healthcare providers are worried about how it will develop in practice, how the actual payouts will be based upon, on what they would be based upon, and only the time will show. Initially, the law would have had to enter into force already in spring, but due to concerns from the insurer side and also due to the general readiness of the market or lack of readiness then of the market, the law was postponed. The aim of the law is also to start better collecting the new database, collecting the patient safety incidents to the new database that would need to develop the well-being of patients and also enable the healthcare providers to really learn from the mistakes and not to be afraid of documenting the safety incidents. The safety incident doesn't always have to result in the actual damage, but it might just be an incident where there is a threat to that. So the second topic I chose for the for you, the audience today, is the medical devices focus. What we see very much in our everyday work is that the Estonian Health Board has putting much focus on the surveillance of the medical devices field. And by that, I don't mean only the surveillance on the manufacturers, because most of the medical device manufacturers are not located in Estonia, but we are talking about inspections towards the distributors of the medical devices. And I wanted to highlight this one provision that has been very problematic, if I may say so, in practice. And we have been approached several times with a question, what does it mean exactly? So basically what the Estonian lawmakers did is that both MDR and IVDR, they allow that the local legislative organs, they may put some additional obligations on the distributors with regards to the registration of the distributed medical devices. And in Estonia, this path was chosen. The law establishes that if the distributor starts distributing medical device on the Estonian market for the first time, and this is especially important, this first time means first time by that distributor. It doesn't matter that the medical device has already been distributed by some other distributor on the Estonian market. The distributor must notify the health board if it itself starts the distribution of that medical device. And that is something that has concerned the market players and also is something that you must be aware of as a distributor of the medical devices. I brought it out here, the points to remember, that Article 14, both in the MDR and IVDR, are the ones to be remembered by the distributors of medical devices. Please go and please check what are your obligations, starting from this, that all the distributors must be sure that the medical devices that they are distributing have the CE mark on them, that they have the relevant certifications, that they have gone through the all the relevant requirements, processes that are established for this particular medical device class. So distributors are not something that is separate from the market. Rather, they are a very important part of the market that must follow all the requirements in the MDR IVDR. And two other points: register of complaints and identification within the supply chain. These are also obligations that have come up from time to time that are kind of new for the distributors, but you need to be aware of, you need to have those documentations in place. You need to be able to show who are those entrepreneurs whom you are selling, from who you are buying, etc., etc. So these were two very quick hot topics from the Estonian side, and I'm happy to give floor to my Latvian very good colleague Marika.
Thank you, Lise. Going on to hot topics in Latvia, I think it's worth highlighting one huge hot topic which has been on the table for the probably whole last year, and it is related to a new pricing model for prescription medicines in Latvia, which will start to be in force from January next year. And this has caused a lot of discussions because stakeholders are not very satisfied with the offered model by the Ministry of Health, which anticipates that the medicine prices should decrease up to 20% for prescription medicines in Latvia. So the new model applies to wholesaler and pharmacy markups for prescription medicines and reimbursable medicines, but at the current moment there are no changes anticipated in respect to wholesale and pharmacy markups for the over-the-counter and unregistered medicine. In addition to this pricing markup regulation, there has also been introduced a pharmacy fee for pharmacist services offered when selling medicines. So a bit shortly, what's new in this new model? Firstly, starting from manufacturer's level, it states that manufacturer's selling price should not exceed the price for the same medicines in Lithuania and Estonia, as well as the manufacturer will be able to change announce price changes only once in 12 months. As regards wholesale markups, there has been introduced one fixed markup regardless of the product price, and this markup will be added to the manufacturer's price, adding to that 50 cents and plus VAT, of course. As regards pharmacies, there have been introduced 3 levels of markup depending on the product price. So this pharmacy markup will be made of price which the pharmacy pays for the medicines to the manufacturer or wholesaler, excluding VAT, and to this purchasing price there will be added price adjustment and VAT, and then these price adjustments will be in the fixed amounts, and the amounts will depend on the purchasing price of the product. So if the purchasing price is up to 2 euros, the markup will be 50 cents. For the price between 2 euros and 100 euros, markup will be 1 euro and 20 cents. And lastly, for the purchasing price over 100 euros, the markup will be 2 euros. And of course, these prices applied by wholesalers and the pharmacies will be the maximum permitted prices. Finally, there will be introduced a fee for pharmacy services, and this fee will be applicable for pharmacy service for the prescription at its first dispensing. If the pharmacy is the only pharmacy in the given settlement. The fee will be in the amount of 1 euro cents per prescription for larger pharmacies, while 2 euros and 50 cents for smaller rural pharmacies. From this pharmacy fee, 75 cents will be paid by customer, by the buyer, while the rest of the amount will be covered from state budget. And there will be some exemptions from this pharmacy fee applicable to some exempted groups of purchasers, such as for prescriptions issued for children under age of 18 years, and as well as needy person, asylum seekers, and persons defined in the law on the support to civilians of Ukraine who fall under this law regulation. So this is very shortly about the main introductions in this new regulation. The main debates that has been around this new regulation is that the markups are not sufficient, and there is high risks that they will not cover actually the costs of distributing medicines, and the smaller pharmacies have expressed the concerns that they might be forced out of the market because they will not be able to cover their expenditures. And so yeah, let's see. Actually, as I said, this will be introduced from the beginning of next year, and then probably we can come back and see how it has actually been introduced in practice. So that was the highlight from Latvia, and now I will give word to my Lithuanian colleague Erika.
Hi, hello everyone. So thank you, Marika, for giving the floor, and a little bit different from my colleagues in Latvia and Estonia, I won't be presenting major changes in regulation in Lithuania. because actually the reason for that is there were no major changes in Lithuania recently, which could be relevant for all the market, for different market players gathered here in this conference. So I was thinking to myself of the reasons why this is so. Why there are no significant changes in Lithuania. So the reason is simple. If we look at the political background in Lithuania, and also this might be interesting for those who are not from Lithuania. So the political background is that here you can see indicated 3 major institutions in Lithuania responsible for healthcare: State Medicine Control Agency, National Health Insurance Fund, and Ministry of Health. And in all of these, changes in main managements happened recently. So, and another thing is we have new elections for parliament in October. So having all this political background, it's only natural that no reforms are initiated and no big changes are made in the legislation. So instead, I will be presenting what has been happening in Lithuania recently, and I will just talk about some interesting or new things that might be relevant for market players. So what has been happening? So the very common tendency that there is major disruptions in the supply of reimbursed medicine, and this is also has been discussed in the State Audit Office, and the impact of this is that the frequent changes in the list of reimbursed medicines are made, and for this reason, it's very difficult for market players to adapt to those changes, and often they're not even aware of the changes when their medicines get off the reimbursement list. And of course, it's a big uncertainty for patients and for healthcare professionals when they are prescribing the drugs. So another thing is that actually, another thing is good news for suppliers of professional medical devices, because now such medical devices, instructions for use for such medical devices may be provided in English language also, not only in Lithuanian. So this is good news because the reasons for changes in this regulation is that professional use and innovative medical devices could be better accessed at healthcare organizations. And also there's another issue, mindsets of healthcare organizations personnel, because we still prefer IFUs to be in Lithuanian language. So but still this is good tendency. So another thing is also a good thing is that now medicines with which are prescribed with Lithuanian e-prescriptions may be purchased in foreign countries such as Spain, Portugal, Greece, Estonia, etc. So impact of this to patient is very good, I would say, because together with remote healthcare services, which are available in Lithuania, also now patients being in Spain may get remote healthcare services from their healthcare provider in Lithuania, and also they can purchase the prescribed medicines being away. So I think this is one of the good examples how innovations may impact healthcare in a good way. So another thing, let's go to the next slide, the next point I would like to introduce you to is that Competition Council in Lithuania has updated guidelines on how associations should act in order to not infringe competition law rules. And what's new in here is that now the guidelines impose even more rules, and organizations and associations and organizations in association must be even more careful when performing lobbying activities, because even more activities of the companies in the associations might be considered as breach of the competition law rules. And the last thing I would like to speak about is also European regulation adopted by European Union related to health technology assessment. This is relevant for pharmaceuticals and medical devices, and this is in particular relevant in Lithuania, and innovative companies have been discussing about it a lot, because in Lithuania we have this huge negative situation where innovative medicines takes more than 500 days to get evaluated, to get the assessment, and to get the reimbursement. So this is twice. This term is twice as long as allowed by applicable laws. So now, when this EU health technology assessment is in place, that it aims that some part of the clinical assessment is made at EU level, and another part is made at national level. So this aims to make innovative health technologies more available and to reduce duplication of efforts by national healthcare authorities. And hopefully it will make also impact to beneficial impact to access of innovative medicines for patients in Lithuania and in Europe as well. So this is all aspects I wanted to talk about.
Okay, thank you, colleagues. Thank you, Lise-Lotte, Marika, and Erika for sharing the novelties. At least for me, based in Latvia, it was also very, very interesting to find out what's hot and relevant currently in Estonia and Lithuania. So before we go to the next presentation, we see that we have one brief question published for Latvia. Marika, might you be ready to answer it right now before your presentation, or rather we write the answer later?
I believe that I will provide in writing afterwards.
Okay, so therefore, then we will go to the next topic, which is competition law. Very, very interesting and challenging topic, which can sometimes have also a huge impact if something goes wrong. So it's always better that the things are taken care of from the competition law perspective. And this topic will be covered by our colleague Marika Grunte from Latvia, who, besides being a life sciences expert, is also one of our best experts in the competition law. So Marika, the floor is yours.
Thank you. Yes, competition law always is relevant for all sectors of business, and especially, of course, for pharmaceutical sector, life science sector, considering that the life science sector is constantly under radar of the competition authorities, considering that it is very important for the society in whole, and it is very highly regulated, and the prices typically tend to be quite high. Therefore, the competition authorities are following the developments, and therefore we decided that it's necessary once again to repeat things that companies acting in the life science sector should be aware of, considering the high fines that may be applied for competition law infringements. So today, in this part, I will shortly go through the practice of the competition authorities in the recent year, where the infringements have been found in life science sector. But before we speak about the practical examples, a bit of theory, just to remind you what is said in the competition law and what causes infringement risks. First of all, there are two main pillars in competition law, two main prohibitions. One of them is general prohibition of cartels, and another one is prohibition of abuse of dominant position. When speaking about cartels, we mean agreements or any arrangements, hidden practices between two or more independent companies, aim of which is agreement of non-competition between these companies. And the conduct of infringement may take different forms. Law defines only examples, so this list is not complete. And the most typical examples of cartels are price fixing, market sharing, bid rigging, as well as restrictions of output, services, client sharing, and so on. When we speak about cartels, it is also important to remember that it's not a civil law, it's not a written agreement or oral agreement, it's any form of collusion we speak of. It can be a formal, informal agreements, emails, any way of reaching a common agreement on in this case, practice which is forbidden. When we speak about prohibition of abuse of dominant position, it's important to remember that being in a dominant position as such is not prohibited, but it is prohibited to abuse this market position. And dominant position in general is understood in competition laws and in practice as a position of economic strength in the relevant market, and this strength enables the company concerned to act at significant level independently from its competitors, customers, suppliers. And by this economic strength, it is able to restrict and distort competition in the relevant market for a prolonged or sufficiently long period of time. What is important to say that many laws provide for market share thresholds for a presumption of dominant position, including Estonia and Lithuania, which is 40%, above which companies should be more careful about their actions in the market and assess whether there is risk that they may be in a dominant position. When we speak about abuse of dominant position, usually there is a three-step test one must done, and it's not an easy test. It's rather complicated because in order to find that somebody has been abusing its position in the market, one must first understand the market, define this relevant market, and assess whether a company actually has a dominant position in this market. And this market defining part might be the most tricky, most complicated, and it consists of defining relevant product and relevant geographic market. And it's important to note that while geographic markets quite often in the life science sector tend to be national due to high regulation and local peculiarities which divides one territory from another. Then as regards product market, these can be defined in life science sector very, very narrowly. Sometimes it can be up to level of one particular medicine. Then, of course, sometimes it is very important and the way of administration of medicine, the route of administration, which can also influence the definition of relevant market. There can be markets maybe defined at the level of international non-proprietary name. So yeah, each case is individual, but at least remember that the relevant product market can be very, very narrow. Once it is found that company is holding a dominant position, and again, remember this 40%, somewhere back in your head when the market shares are 40 and above, you should at least become careful and make probably a more in-depth assessment of the situation. Then then the next step would probably be assessment of the possible abuse of a dominant position. And again, just as in case of cartel agreements, also in case of abuse of dominant position, competition laws typically give a list of examples. It means that those examples are the most typical abuses found in practice, but this list is open, so there can be also other cases undefined by law. And typically, that most oftenly found forms of abuse relate to prices, either excessive pricing or predatory pricing, which means very low, below cost pricing aimed at removing remaining competitors out of the market. Also artificial restricting product development or product sales, discrimination of trading partners, failure to supply to the buyers without justified reasons, tying of products, which means that you supply a dominated product tied with another product which is not needed for the customer, as well as abusive rebate systems, and in particular loyalty enhancing rebates that can cause competition law infringement risks. And now when we have had a little bit of theory, we can look in examples from the recent years, what has been on the radar of investigations. First of all, these are various cases related to restricting of competition coming from generics or biosimilars. And as you know, that when patent ends, then generics and biosimilars are pushing into the market. And according to European Commission study, actually prices for innovator drugs, medicines at this moment drops up to by 40%, and generic products are often priced even up to 50% lower than the original. And therefore, many original companies try to minimize this impact of generic and biosimilar competition by using different practices which can be established as infringing competition laws. For example, there have been cases where patents have been misused by the patent holders. For example, the recent case by European Commission, which is still pending, the company allegedly used tactics in several European countries to extend the exclusivity of their medicine and delay the entry of competitors. And this tactics included the misuse of patent procedures, where the company filed various divisional patents with overlapping content and then withdrew parent patents when they were challenged. And thus they created legal uncertainty on the market and delayed generic medicines market entry. This case is still pending, so we cannot give at least further comments on that, but be aware of such situation. Also, there have been cases called as abusive litigation, for example, when filing claims before a court in order not to defend own rights, but rather to harass the opposing party as part of a plan to eliminate competition. And in case this is done by a dominant company and there is no really objective reason for such a claim, and such practice actually can be found as abusive litigation. Also, the same relates to similar activities as requesting, for example, preliminary injunction from courts, where there is a not purpose to protect companies' own rights, but rather this objective is to hold competitor from launching a product and therefore eliminating competition on the market. Of course, as mentioned, discounts or dominant firms should always be aware of discounts, and this is a case I wanted to highlight from 2019 by the Dutch Competition Authority, which investigated AbbVie company with former patents, which after ending of patents had offered hospitals huge discounts for its medicine Humira. And the precondition was to continuously use this medicine over already cheaper biosimilars available on the market. And of course, such practice made it harder for biosimilar manufacturers to enter the market. And the competition authority found out about this practice, and after that, this company removed these discount conditions, and the investigation was closed. Excessive pricing, this is just another example of a dominant company. In this case, it was in Denmark in 2018, where Danish competition authority found that the distributor in Denmark had abused its market dominance by raising the price for its medicine for 2,000% in the period between April and October of the same year. And since it was the only product with the Danish market approval, it was in a dominant position, and such practice was established as abuse of dominant position in the market. Also, from more recent cases, it's worth mentioning the European Commission case from 2021 regarding pricing. And it is related to Aspen farm care company, where European Commission found that it had applied excessive prices compared to the profit levels of similar companies in the industry, and they had charged excessively high prices for 6 off-patent cancer medicines, which resulted in substantial profits for this company without justification. So during the case, Aspen committed to reduce its price by approximately 73% across the Europe, as well as took other commitments, for example, capped prices for 10 years, ensuring constant supply for at least 5 years of the medicines. Then there is another quite broadly used practice, which is pay for delay agreements, and these can constitute both cartel if concluded by similar competing players, but it can also constitute abuse of dominant position if it is exercised by the dominant company. And pay for delay agreements involve deals between originator and generic companies where the first delays its market entry, and in exchange it receives significant benefits from the originator. And in such case, of course, both parties are winners because the originator gains extra profits from this extended market exclusivity, and the generic company receives a share of these profits without actually entering the market. Lastly, there is such practice as disparagement, which in essence is spreading false or misleading information about the competitor's products, which can actually mislead healthcare providers, patients, and of course harm competition in general. So if such practice is applied, for example, by a dominant company, then it can also lead to competition law infringements. And finally, why it is so important to always remember about competition law and now competition law and understand these prohibitions. It is because breaches can lead to huge consequences. Firstly, it is these big monetary fines, which can reach millions of euros. In the European countries, as well as at the European Commission level, the fine can reach up to maximum of 10% of the group's worldwide annual turnover. In some countries, there can be even criminal fines, like in Estonia, for example. then there is the risks that the agreements that have been concluded in breach of competition law are actually legally void and invalid. There other big risk companies are afraid of usually is damage claims, because usually competition laws provide for rights for those persons who have suffered damages to claim these damages in court. And finally, it's very important to remember that in many countries, competition laws provide for leniency programs, which means that companies that have been parties to a prohibited agreement, for example, cartel agreement, they can go to the Competition Council, bring all the evidence about all the involved persons in the cartel, length of cartel, and so on. And in return for this cooperation, they can receive huge, significant reductions of fines or even full immunity from fines. And these leniency programs, they are being used more and more often. So there's always a risk if a company is a party to a cartel, that some other member of cartel may use this choice provided by the law. So this was shortly about competition law. I hope you don't face any problems in this area, but in any event, if you are in doubt, always ask and consult. We will be happy to help you. Thank you.
Thank you, Marika. That is very interesting and insightful presentation. We don't have any new question on the competition law, but we do still have this question on the pharmacies' rights to purchase medicine directly from the manufacturer, passing by the wholesaler chain. Would you like to address it, perhaps?
Yes, by that we mean manufacturers who have a wholesaler distribution rights license.
Yes, I think the answer then would be that pharmacy cannot buy directly from the manufacturer unless the manufacturer also, in addition, has the pharmaceutical wholesale license.
Yes, exactly.
And yes, and we just also received comment from our Estonian colleagues. The situation is the same in Estonia, so might be pretty common in our countries. Okay, as we don't have any other questions, then we can pass slowly the microphone to my Estonian colleague, Lise-Lotte, who will now talk about the technologies and the advances of the artificial intelligence and what connections AI has with the life science sector. Lise-Lotte, please, floor is yours.
Well, the AI topic is definitely a very, very hot topic for the time being, and I think that it is very safe prediction to say that it will remain hot topic for many years to come, because right now what we see on the market, it's just a very small part of the actual capability of the artificial intelligence capacity to change the way we work, the way we provide healthcare, and all the other fields in our everyday lives. And why this is a very hot topic is that probably many of you have already heard that the AI Act was adopted after many years of considerations, heated disputes. The AI Act entered into force on 1st of August this year. The 1st of August basically is now the date where we need to calculate all the other important dates that needs to be remembered by the market participants, because of course when the legal acts are adopted and they enter into force, that doesn't necessarily mean that they apply from the moment entirely. with the AI Act, what is very important to understand that the European Union legislative acts can be divided on a high level to two categories. We have legislative acts that need to be interposed somehow to the local laws, and then we have the legislative acts that are directly applicable. And the AI Act is regulation that is directly applicable to all the member states, which means that they do not have to adopt any special legal acts in order for the AI Act to be applicable. So when we talk about the healthcare, the main date that needs to be remembered is the 2nd August of 2027. I will delve into it later on during the presentation, but why I say that this is one of the most important dates from the AI Act is that this is the date when the high risk AI systems, also medical devices that fall under this category, would need to comply with all the obligations foreseen for them under the AI Act. Now, before we delve into the interconnections between the AI Act in general and the impact it has on the healthcare sector, I wanted to very briefly touch upon the main scope definitions coming from the AI Act. The first, of course, is the main definition: what is the AI system? The AI system, as you can see, I have brought out the bits and pieces from the definition, trying to highlight the most important parts for you. The AI system is the machine-based system that has autonomy and that infers from the input it receives some kind of output that can influence us somehow. So I think the most important word from the definition of AI system is infer, because infer refers to the ability to do something bigger from the material that you've been given. And I think this is the if somebody's asking from you, how do you explain the AI system, then I'm always using this word and trying to demonstrate that this has the level of autonomy, the level of this capability of creating something bigger. Then, of course, what is very, very important, and this is also kind of a trend of the latest European Union regulations and legislative trends, is that it has extraterritorial effect. Well, we'll see in time how it will develop, how exactly it is possible to demand the compliance with the requirements deriving from the AI Act from the companies, from the entrepreneurs who are not located inside the EU. But based on, since I have also been involved and advise everyday clients in relation to the data protection questions, then based on the GDPR experience, I would say that AI Act has potential to become something similar. It has potential to become a role model legal act that is somehow reflected or even sometimes copy pasted to other jurisdictions' laws, because I think we have the common understanding now in the world, or at least in the countries that are more in depth into the use of the AI systems that we need the regulation, and having the one common AI Act for I think it is indeed a better solution than having all the different solutions in each and every single member state separately. So definitely AI Act will have more impact than only this impact in this European Union member states countries. And then important definitions are providers, and I would emphasize on deployers. We will look into employers more specifically later on, but you need to remember that providers are companies, undertakings that develop the AI and they place it on the market or put it into service. And deployers, on the other hand, are the users. Like, I think everybody here has already used ChatGPT. So far we are using it only for our personal capacity. We are not deployers. However, if we start using the ChatGPT for the provision of some kind of a professional services, we might end up being a deployer under the AI Act. Now, the impact on life sciences and healthcare sector. I must admit that the work in relation to the AI Act started much sooner than the AI Act actually was adopted. And the reason being that the companies who are already developing the relevant AI systems, or they are using the AI systems in their everyday work, they understood that something is coming, and many companies are already now very aware that they might do something in the future. They might need to do something in the future under the AI Act, and that is the reason why we are always emphasizing to our clients that it is a very good attitude to rather start preparing sooner than later. Otherwise, it will happen like with the GDPR, that we are still in the phase where some companies are drafting the privacy policies. So the connection with the AI Act and the life sciences and healthcare sector is quite strong. And the strongest link that is visible for the time being, and what I see just from the work that arrives on my table, is that medical devices might be high-risk AI systems. And what does it mean to have the high-risk AI? The Article 6 of the AI Act establishes that when the AI system fulfills both conditions, you see them on the screen, that either this product itself is regulated under the EU legislation listed in Annex 1 of the AI Act, or it is a safety component of that product. And then the second condition that must be simultaneously fulfilled is that the product must go under the third-party conformity assessment. And in the Annex 1, that is especially important from the perspective of healthcare, is that it also mentions the MDR and IVDR. And if we look into the MDR and IVDR, then we see that with class 2A, 2B, 3 devices under the MDR and under the IVDR PCD devices, you would need to go through the notified body assessment to have the relevant certificate for your device, and that means that you would also fall under the definition of the high-risk AI system. It doesn't necessarily mean that the medical device itself under the MDR or the IVDR would qualify as very, very high risk device, because we know that, for example, 2A might not be high risk device under the MDR, but from the perspective of AI Act, it falls under the category of high risk AI systems. And I also brought out here the safety component reference, because it has in practice raised questions like, what does it mean that it is a safety component of that product? Well, to be clarified very simply, this means that this symptom, this component in the product that, for example, is 2B device under the MDR, this component that entails the AI system might have a very important function in the process of the functioning of this product, and it might result if, for example, this AI system breaks down, or there is some kind of a dysfunction with this AI system, there might be a danger to a patient's life or health. So again, as I pointed out, only time will tell how the actual implementation of the conditions in the AI Act will take place. And we will see it through the case law, we will see it through the practice of the relevant authorities. But anyway, what you have to remember is that when you have a medical device, in vitro diagnostic medical device, that you're either using or you're producing it or developing it, then you have to check whether your device might fall under this category of being a high-risk medical device, high-risk AI system. Now, the key requirements, I have discussed with my colleagues about the impact of the AI Act, and the common understanding about within the circle of lawyers about the AI Act is that it is very similar again to the GDPR approach, that it is a risk-based approach. The legislator chose like what are the most dangerous AI systems that could be placed on the market. Where are those areas where we need to protect human beings and we need to protect our society from those dangers? And that is the reason why the AI Act approaches this, that we have this high-risk AI systems where obligations are quite heavy, and you really, if you're involved somehow with the high-risk AI systems, then you really need to delve into the AI world, AI Acts world, and understand how the application would take place. But on the other hand, like using it in your everyday life, the AI systems, or having the general understanding of the AI systems, then the obligations deriving from the AI Act are quite general and quite common sense, in my opinion. Now, coming back to the high-risk AI, then with high-risk AI, you would need to definitely have the risk management system that is suitable considering the intended purpose of this particular AI system. And that entails the data governance and management. You need to understand what is this data based upon which you are producing the AI system, you are providing the AI system, and it is of utmost importance that the data that is used is appropriate, that the data is collected correctly, that data is collected legally, that you have examined possible biases. The biases topic is totally a huge topic, and this is something to be considered definitely in the future, how to avoid biases when developing the AI. And then all the record keeping, logging obligations, technical documentations, transparency and human oversight, accuracy, robustness, cybersecurity, all those obligations should be read by row and really made clear for themselves, for yourself. I will little bit now move quickly forward to the second area, which I wanted to highlight in relation to the healthcare, that the second question, what we see coming onto our tables in everyday work, is that how do you use the AI in the healthcare provision? Like we have medical devices developers, and they cover all the manufacturers part, but how do you use it in the healthcare? And then we come upon again to this deployer definition, and as I mentioned before, this has to be used in a professional activity, and with the deployers in the healthcare providers, essentially, what is most important to them is the human oversight part. The human oversight is specifically regulated in the AI Act, Article 14, and this, in my opinion, is one of the most difficult parts of the implementation of AI systems within the healthcare, because how can we ensure that this human interference is actually effective, and actually can we avoid the mistakes being made when using the AI system? And that brings us to the key challenges. First of all, the ethical and structural challenges. Where do we draw the line? What we see in practice when we have led the projects covering several EU countries, when the question is like, is it possible to use this AI system within your healthcare process? Then we come upon to this obstacle that since this is something new, then we are reluctant to use the AI systems within the healthcare provision services, as we are afraid of this the system because we don't know it. We are not very sure about the how the AI system has been put together, and this also relates to this AI literacy that I'm referring to on the slide. AI literacy is something that is a core principle written to the AI Act, that all the users of AI on the market, providers, importers, distributors, deployers, they need to have the literacy. And without the literacy, it is impossible to also apply the human interference factor to the provision of healthcare. The doctor who is usually maybe using the AI system as a regular medical device maybe, and trusting the output that is given to him from the AI system, needs to understand how the AI system works, needs to understand where the possible mistakes may lie, and how to then protect yourself from those mistakes. Because, as it is put on the slide, the provision of healthcare for the time being in most of the European countries is still an act by a natural person ultimately, and so the time will show how the liability issues in the contrast between the activities of natural person and activities of the AI systems will be solved. But thank you.
Thank you, Lise-Lotte. That is very interesting. We don't have any new questions right now. I actually do have one question on the AI Act, but in order to keep us on the schedule, I think we can discuss it at the very end in the summary session. So now we will turn to the topic of the pharmaceutical patent litigation, which is actually quite relevant nowadays in all 3 of Baltic countries. And this topic will be discussed by Senior Associate from our Estonian office, Olivia Kranich. Olivia, the floor is yours.
Thank you, Ieva. Yes, you are correct that in recent years we have seen a rise of patent litigations in the Baltics. Many patents protecting blockbuster products are about to expire or are expiring, and therefore a lot of generics are trying to enter into the market. A key tool for enforcing patent rights is a preliminary injunction, in short, a PI. In patent litigation cases, the outcome is often essentially decided in the PI stage. This is particularly true for the Baltic countries due to the market size. In case a PI is granted, a generic company may not be interested in continuing with the dispute as it loses the benefit of early entry in the market, or in case the PI is not granted, depending on the patent expiry term, the patent holder might not be interested in continuing the dispute in consideration of the cost of the dispute and potential gain from damage compensation, or might be interested in delaying the proceedings. A preliminary injunctions basically it allows you to apply for the court to prohibit a generic product to enter the market. The prerequisites for requesting a PI are the following. First, it is likely that the right being enforced or intended to be enforced in court, the patent, is real and valid, and there is an imminent threat of infringement of the relevant rights. The patent is about to be infringed. And in disputes concerning monetary claims, there is a reason to believe that the failure to impose the preliminary injunctions may render enforcement of judgment difficult or impossible. This means that the plaintiff would need to demonstrate to the court how failing to impose the PI would render the enforcement of a future claim difficult or impossible. Or in disputes concerning non-monetary claims, the PI is necessary for the prevention of significant harm, arbitrary action, or for other reasons. The plaintiff would need to demonstrate to the court how failing to impose the PI would cause harm which cannot be later compensated. In most cases, patent litigation starts with the patent holder's claim against the generic to refrain from the infringement. This is a non-monetary claim, and therefore the patent holder needs to demonstrate the threat or of a significant harm or arbitrary action. A common argument is that as soon as the first generic hits the market, the price of the patented product drops and never recovers. Timing is of the essence when filing a request for a PI. There needs to be an imminent threat and therefore a sense of urgency. From the patent holder's perspective, it is crucial to secure a PI before the product reaches the pharmacies. However, filing a request too early may allow the generics company to argue that there is no real imminent threat of infringement. Different jurisdictions have different rules on when can the request for PI be filed. Since a marketing authorization does not mean that the product will be made available in all territories covered by the authorization, the granting of marketing authorizations is normally not considered as creating an imminent threat. In Estonia, it's a common understanding that the threat of a generic entering the market becomes imminent when it is included in the reimbursement list. Essentially, as of being included in the reimbursement list, a product becomes financially accessible and therefore available to the public. The reimbursement list in Estonia is updated quarterly on January 1st, April 1st, July 1st, and September 1st. However, information about the planned changes may become public before the product is officially added to the reimbursement list. It could be argued that the mere inclusion of a product on the reimbursement list does not necessarily constitute imminent threat or of infringement. This is because in past inclusion of the reimbursement list imposed an obligation on the manufacturer to make the product available within a certain time frame. So the manufacturer entered into agreement with the health insurance fund and was obliged to bring the product into the market by specific time. However, increasingly products are being included on the reimbursement list with a clause stating that they will only may be made available once the patent, underlying patent protecting the original product has been invalidated. In cases where there is no obligation to supply the product, there is likewise no imminent threat of infringement. In Latvia, a PI can be requested when the generic enters the local market. That is, it becomes available to the consumers. And in Lithuania, PI can be requested when the generic is included in the reimbursement list. The court, however, may refuse to grant an injunction if too long time has passed after registration of the generic product. One thing to consider is the type of proceedings. Ex parte proceedings means that the defendant, the generic, is not involved until the court makes a decision. Inter partes means that the generic is given the opportunity to respond to the PI. In Estonia, ex parte proceedings are standard. For PI proceedings, the court may decide to hear the defendant when it considers it reasonable, particularly in cases where the PI will regulate the disputed relationship. In recent years, inter partes proceedings have been used in an increasing number of patent litigation cases. One reason may be that this helps to save resources otherwise used in appeal proceedings, because if you grant the PI ex parte, it's likely that the defendant will appeal it. The court makes reasoned order in PI matters not later than on the working day following the day on which the application was filed. This is for ex parte proceedings. Inter partes, it could take a little longer, but usually it's doing. The courts are solving them very quickly. And PI proceedings are normally conducted in Estonia in written form. In patent litigation cases, PIs are more often granted than not granted in Estonia. However, recently this practice has been changing. In more and more cases, the courts deny PI in case there are serious doubts in the validity of the patent. In Latvia, ex parte proceedings are also standard. The court may opt for inter partes proceedings when the judge believes that additional evidence or information is needed in order to decide on the injunction. In ex parte proceedings, the court must make a decision within 10 days after receipt of the application, and inter partes decisions are made within 15 days. If delay may cause irreversible harm to the patent holder, the court makes the decision no later than on the next working day without notifying the defendant. Deciding the next day to prevent irreversible harm is not usual practice in pharma patent litigation cases in Latvia. PIs in Latvia are often granted with a higher likelihood of being granted than not granted. In Lithuania, the law provides that the court notifies the defendant when the court finds it necessary to notify. However, according to the case law, the courts must always provide motivation for not informing the respondent in the decision to grant the injunction. Therefore, Lithuanian courts, especially in patent litigation cases, tend to notify defendants about the PI requests. Notice to the defendant does not require the respondent to provide a response to the application. However, the court usually allows the defendant to respond. Usually they are giving a short term for this, maybe 2 working days. Applications for PIs are usually investigated in written proceedings without hearing oral arguments of the parties and without parties participating in a court hearing. A decision can be expected within 1 week. Lithuanian courts very rarely grant PIs in patent infringement cases. To grant a PI, the court must come to a preliminary finding that the claim is likely justified. In patent cases, the court must determine with a higher level of certainty that the claim is justified because the grant of PI, which essentially coincides with the main claim to prohibit the infringement in the future, in patent disputes is usually associated with highly significant consequences to the respondent. Therefore, following proportionality principle, it can be justified only when the infringement is sufficiently clear. In deciding whether to grant or deny the PI, the courts will consider likelihood of success. This includes an assessment of whether the patent is likely valid, meets the patentability criteria, and whether it is likely that the defendant infringes the rights conveyed by the patent. The court may also consider whether the patent has undergone opposition or revocation proceedings, which could cast doubt on its validity. And while decisions from courts in other jurisdictions are not binding, they may be persuasive, particularly if they form a consistent trend regarding the patent validity or infringement. A history of decisions in favor of or against the patent may weigh into the court's analysis. Another thing that the courts will consider is urgency. This includes assessment on whether the infringing activities have already taken place or are about to take place. Is there an imminent threat of infringement? They also consider balance of interests. The patent holder has a legitimate interest in enforcing their exclusive rights and preventing unauthorized use of the patented technology. On the other hand, the defendant has an interest in entering or remaining in the market. And injunctions could cause significant disruptions to their business, particularly if the patent is ultimately found to be invalid or not infringed. The court may consider the broader public interest, such as the availability of products or services in the market and the use of judicial resources. Public interest can also factor in situations where the patented invention involves public health or essential technologies. Then there are security deposits. The court may make the granting or maintaining of PI contingent on the provision of security to cover any harm that may be caused to the opposing party or third party. In Estonia, the courts usually grant interim relief in relation to a court claim for monetary relief only where security is provided in the sum of at least 5% of the amount of the relief sought, up to 32,000 euros. This is what we see also in patent litigations, is that it is very common for patent holders to file PI requests and already pay the deposits voluntarily, because this will make the process easier and they are able to get the PIs granted more quickly. In recent years, a new strategy for generic pharmaceutical companies has been to involve local health insurance authorities into the legal proceedings. During the PI stage, this strategy can shift the balance in favor of generics by appealing to the public interest. It is in the public interest to have greater access to medical products at lower costs, meaning consumers pay less and the health insurance system save money on medications. Health insurance authorities can intervene to argue that granting a PI would lead to misuse of public funds as they would be forced to pay higher price for medicines than it is justified. While it is fair for originator companies to enjoy a period of exclusivity and higher prices to recoup the investments in research and development, this justification weakens when the originators attempt to extend patent protection through multiple patents covering the same inventions. In such cases, the exclusivity and resulting high costs are not justified. Health insurance fund authorities therefore have an interest in ensuring they are not misusing public funds by paying inflated prices for longer than necessary. Another reason for involving authorities is that it makes it easier for them to claim compensation for damages later. If the local health insurance fund participates as a third party in the proceedings without an independent claim, it simplifies the process for them to seek damages compensations at a later stage. At the same time, it might have effect on the thought process of the patent holder, because the threat of potentially being obliged to later pay damages not only to the generic company, but also to the health insurance authorities may make them reconsider whether they really want to file their PI applications and court claims. For generics, there are certain countermeasures available. First of all, protective letter is used to preemptively present the defendant's position before an injunction is granted. It helps to avoid ex parte decisions where the injunctions could be issued without the defendant having the chance to argue their case. So basically, a protective letter is sent to the court to notify that there might be a court claim from the patent holder, but already argues why this claim is not justified and why the PI should not be granted. There is no official procedure in Estonia for submitting a protective letter, but theoretically it is possible to notify the court. And then there is a counterclaim. The defendant may file a counterclaim seeking the invalidation of the patent. In case of inter partes proceedings at the PI stage, it might be wise to, from a strategic perspective, to submit a counterclaim together with the response to the PI request. This demonstrates to the court that the defendant is serious about the invalidity claims. In some jurisdictions, a claim for a patent invalidation is subject to mandatory pre-trial proceedings at the Board of Appeals, and exceptions are made for counterclaims in the proceedings. So it might be that if you want to attack the patent without having a claim from the patent holder, then you would need to go to the Board of Appeals first. But in case an infringement claim is filed against you, then you can make a counterclaim of the patent being not valid. Invalidation claim to the Boards of Appeal. In some jurisdictions, patent invalidation can be pursued through administrative or quasi-judicial bodies such as a Board of Appeals or patent offices, instead of or alongside the court. So you can file the patent invalidation claim before a claim is brought against you, or you can also do it in parallel. It could be that these bodies are more efficient and more quicker to process the matter than traditional court, but it depends very much on the jurisdiction and the respective bodies. It could also be that the court will solve the matter much quicker. There is also a claim for compensations of damages. Generics company can claim compensation for damages if the PI is found later to have been wrongfully granted. This includes lost profits and harm to the reputation and other financial losses incurred to the injunction. As I said, knowing that they could face damages claim may cause patent holders to be more cautious when seeking PI measures without solid grounds. Strategy of the parties is affected also by the burden of proof. The patent holder must prove that the defendant has infringed the patent. This typically requires a comparison between the patent claims and the accused product or process. Proof of infringement involves showing that all elements or at least one patent claim are present in the defendant's product or method. An exception is foreseen for cases where the patent protects a method, a manufacturing processes. Here the burden of proof is shifted, and it is actually the defendant's obligation to demonstrate that is using a different method when the final product is the same as made by the patented method. Initially, the patent is presumed valid, but if the defendant challenges its validity, the patent holder may need to defend its compliance with patent law, novelty, inventive steps. In some jurisdictions, once the validity is questioned, the burden of proof can shift, requiring the patent holder to demonstrate the patent's validity. The defendant must provide evidence that their product or process does not infringe on the patent claims. This involves a claim construction analysis to show that one or more elements of the patent claim are not present in the accused products. If the defendant challenges the validity of the patent, they bear the burden of proof for these claims. This includes providing evidence such as prior art or technical arguments to demonstrate that the patent should have not been granted. If the patent holder asserts infringement under the doctrine of equivalence, they must prove that the differences between the patented invention and the accused products are insubstantial. It's common to use expert witnesses in explaining technical aspects of the case. Both sides can rely on experts of their own, but also it could be the case that the court will appoint an expert to explain whether there are any issues with the invalidity of the patent. We talked about the national proceedings, but there is also a possibility of proceedings at the European Patent Office, a unified patent court. So if there is a European patent which is designated or validated in different member states, and then the proceedings can also take place at the European Patent Office. After a European patent is granted, third parties have 9 months window to file an opposition with the European Patent Office. If the opposition is successful, the patent may be revoked or amended, and this applies across all the designated member states. If simultaneously with national court proceedings on a matter relating to the validity of a European patent or to the protection of the rights of the proprietor of the patent, the European Patent Office has commenced proceedings regarding the opposition of the European patent, then national court proceedings shall be suspended. So if there are opposition proceedings in the European Patent Office, the national proceedings are suspended until there's a decision on the validity of the patent made at the European Patent Office. In addition to European Patent Office opposition proceedings, patent invalidation can be pursued separately in each designated member state. So we can have the dispute in Estonian, Latvian, Lithuanian, and other jurisdictions, and these proceedings will cover whether the patent is valid or whether the infringement is present only in relation to these specific territories. But this may lead to a situation where patent is valid in one member state and not valid in another member state, and very different decisions. We also have a new regulation of unified patent courts. The unified patent courts has exclusive competence over disputes related to the European patents, unless they're opted out, European patents with unitary effect and supplementary protection certificates, SPCs. This includes matters such as patent infringement, revocation, and provisional measures like PIs. So in European Patent Office, we are only disputing the validity of the patent. In Unified Patent Court, you can also bring infringement claims. Unified Patent Court rulings have a broad impact as decisions are enforceable in all participating member states. And this system avoids the need to have separate litigation in multiple countries, making it efficient for patent holders and generics to solve the disputes. But of course, it's a question of strategy, whether you want to put all your efforts into one litigation case or have them in different jurisdictions and maybe have patent rights longer valid in some member states or on the others. If at the same time the opposition proceedings are ongoing at the European Patent Office, then Unified Patent Court may suspend, similarly to the national courts, may suspend its proceedings. And then they will take into account when the European Patent Office finds whether the patent is valid, invalid, or needs to be amended to remain valid, then the UPC, Unified Patent Court, will take this into consideration. This is it from me today. Thank you for listening.
Thank you, Olivia. Patent litigation is a very complicated topic, but I really believe you shed some light on that today. So now we proceed with the next and final topic, which is the new perils of product liability regulation delivered by our senior associate from Lithuania, Erika Žigute. Erika, floor is yours.
Hello, Thank you, Ieva. And I will now discuss another new regulation in just a second. I think I will change the sharing mode. Okay, now it's okay. So I will discuss another regulation, new regulation in European Union, and it's related to product liability. So before we start on new regulation, I would like us to remember what product liability directive is all about, how it works now, and what it's used for. So product liability is an instrument for consumers to claim damages from manufacturers of the product in case of death, personal injury, or property damage. And this directive is aimed for consumers to make easier recourse from the producers in case of damage. The directive is not directly applicable, and each country, each EU member integrates directive and has integrated directive into national courts. And for consumers to enforce the regulation, consumers have to file a lawsuit in national courts and to prove that the product was defective, that he suffered the damage, and there is a causal link between the damage and the product. And what's specific about this regulation and why it is aimed at consumers and intends to make their litigation easier is that they don't need to prove manufacturer's negligence. So this is also called strict liability institute. So for whom in the life science sector the product liability directive and regulation is relevant? So actually for all types of products, including pharmaceuticals, medical devices, technology medical devices, artificial intelligence medical devices, food supplements, cosmetics, biocides. And so why the changes were needed and why the changes were implemented? So actually the existing product liability directive is already 40 years old, and it was adopted while we were living in a different world of things. And interesting fact that actually adoption of such regulation, which is intended for consumers to make easier litigation, was, among others, encouraged by high-profile cases related to negative aspects of medical products, where pregnant women consuming particular product. Later, there were many injuries in the child's born in relation to consumption of such medicine. So interesting enough that the existence of current regulation was encouraged by the pharmaceutical products in general. So why changes? To reflect the nature of products in the digital age and to ensure individuals to even better access to protection in case of complex cases and complex products. So how much directive is relevant to life science sector? And the interesting fact that according to statistics, the second highest number of cases involving defective products was pharmaceutical products, as you can see in the chart. So claims were mostly related to medical devices such as breast implants, pacemakers, metal and metal hips, but also to vaccines. Me with my colleagues in Latvia and Estonia, we have also looked how much consumers have used product liability directive in the Baltics, how many claims were filed in relation to the life science products. So actually, as you can see from the screen, there were many, very few cases, and most of them in Latvia and Estonia were related to dental services and damage of patients suffered due to dental services. And in Lithuania, there also has been one interesting case where consumer died and the death was caused by bacteria found in the swimming pool. So the provider of the swimming pool services was held liable for this death. So far there are very few cases in the Baltics, but since the consumers are getting more and more educated about their rights, so I believe that there is a possibility and tendency of increase of the litigation in this area. So now I will switch to more legal stuff. Sorry about the heavy slide. I will read it out loud for you to make it easier to understand what's new, because this is important for you to know, because you can get better prepared and better understand new regulation. So as I've mentioned before, the first thing is that new products are now in scope, such as software and AI systems and digital services. So this mostly related to medical devices that rely on artificial intelligence, medical apps used every day by the consumers, such as wearables, etc. So now it's not clear that they fall under the product liability directive regulation, but after new regulation comes into effect, so it will be all clear that these devices are also covered by this regulation. Also, what's interesting to know, not only for manufacturers, but also for importers or providers of warehousing services, packaging services, distributors, that they also might be considered liable for defects in the products, even though they are not manufacturers of the products. And this may be in cases where manufacturer is outside the EU or manufacturer may not be established. So this is important for all of you who are providing such services to look into your agreements with manufacturers and to make sure proper liability clauses are in place. Also, there is new disclosure requirement in the directive, which obliges manufacturers to provide necessary information for consumers that they could use to support their claim. So this means that manufacturers will provide consumers with information, also sensitive information to the product, that consumers can better build the claim and to claim for damages. Another new thing is presumed defectiveness of the product. And this is important because when defectiveness of the product is presumed, consumers won't be needing to prove that product was defective, but manufacturers will need to prove that product was not defective in order to avoid compensation of damages. So there are certain cases where the defectiveness will be presumed, but this is very relevant to pharmaceutical and medical devices, because this presumption applies to products which are complex on technical level. Another new thing is that new types of damages are indicated in the new directive. So these are psychological health and destruction or corruption of data, which means that consumers can claim that they suffered psychological health from the product, from the defective product, and manufacturers would have to compensate such damage. Another new thing is that the minimum damage has been cancelled and limits for compensation. So for now, the minimum thresholds where consumers can file a claim is 500 euros. And when new regulation comes into effect, there will be no such threshold, and this means and has significant risk in relation to mass claims, because when even suffering minimum damage, consumers can combine their claims and demand damage from manufacturers. Also, new thing is exemption from liability. So now the regulation says that manufacturers shall not be liable if the defect in product did not exist when the product was placed on the market, in cases where damages occurred later. But now there is the exemption that this shall not apply to software and software updates, which means that providers of software and software updates have to make sure, like for a long lifetime of the software, that it contains no defects. And the last thing I will be discussing, what's new in this product liability directive, is extension of claims period. So now the rule is that consumers must file a claim to the manufacturer within 3 years as of occurrence of the damage, but not later than within 10 years following placement of the product on the market, which means that in case product is already for, let's say, 12 years on the market, consumers can no longer file a claim despite even despite the fact that they suffered damage. For example, in case of medicine, some negative effects may occur to the consumers delayed. So now this 10 years period has been extended, and instead of 10 years, manufacturers shall be liable for 25 years in case of latency of the injuries. And as said, this is of particular importance to the manufacturers of pharmaceutical products. So why the business is concerned about the new product liability directive. So the logos you see in this slide are of associations mostly, which provided their concerns to the EU authorities while the directive was still under discussions and under negotiations. So major marketplaces are concerned about this new regulation because they say that the new regulation may undermine Europe's competitiveness. And they are also very unhappy about disproportionate disclosure requirements because we feel that this causes threat to their commercial secrets and know-how in products, and that they might be forced to settle the claim in order not to disclose the sensitive information. So all in all, what they say that instead of innovating, now manufacturers will have to be litigating, and as a result, prices of the products and availability of the prices of the products will increase, and the availability of the products will likely to decrease. So therefore, negative results consumers will feel the negative results in the end. So when will the new product liability apply? So the new product liability is now adopted by the Parliament, but it's still waiting for adoption by the Council, EU Council, to get in force. And after that, the directive will still be needed to implement into national laws of the EU member states. So it is expected that that locally applicable laws will enter into force in the end of 2026, and it will apply to products placed on the market 25 months after entering into force of the directive. So the last slide is for you, the main takeaways, what needs to be done by the market players to prepare for this new regulation. So first of all, of course, we have to monitor when directive is implemented into local laws. Another thing, what I have already mentioned, so you have to, because supply agreements are often concluded for long time periods, so you have to start reviewing them now with new partners in order to properly allocate liability risks. Then, of course, you will be needing to review internal procedures because retention periods must be in line with GDPR and also with new obligations established in the Product Liability Directive. Of course, then we will see many things in the Product Liability Directive are still not clear, and it's up to the courts how practice will evolve and how strict it will seem in the practice. So we will be monitoring how it is interpreted by the courts. And of course, so everyone forecasts that the businesses must prepare for an increase in the claims and in number of litigations. So that's everything I wanted to tell you today.
Thank you, Erika. That is also very useful information, especially how to prepare. Now I see that we have about 5 minutes still left in our schedule. As we don't have any questions sent in by the audience anymore, I will take the liberty to ask a few questions which I'm myself curious about and which I think might be useful also to some of our listeners. And my question would concern the artificial intelligence, and therefore it's addressed to my Estonian colleague Lise-Lotte, who made a presentation on this. And the question is, what should the healthcare companies do right now before the AI Act comes fully into force only in 2026? So we have still 2 more years to go. And what preparatory activities, if any, should be done right now? Thank you.
Thank you, Ieva. Yes, well, my first recommendation to all clients who have asked this question, because this is not the first time we have been asked, the first exercise that you have to go through, and all companies must do that, is please check what kind of AI systems are you using for the time being, and what kind of AI systems are you planning to use in the near future. And then if you have mapped your systems, you understand which ones are necessary, maybe some aren't anymore, then we can go forward and carry out the either artificial intelligence audit, or you can just ask the general overview of the requirements applicable to your particular AI systems. And I want to emphasize it, what I said before, that in case you would have any high-risk AI systems, then of course this due diligence process in that regard must be very proper, and details must be followed very, very closely. Thank you.
Thank you, Lise-Lotte. And my other question is also quite practical, and I would like to ask it to our Latvian colleague Marika Grunte. You discussed the competition law rules and also what grave consequences happen if something goes wrong in this area. So my question would be, what precautions do you suggest that life science sector companies take to avoid competition law infringements?
Yeah, it's a good question, and it's what I would say, do your homework. And by doing homework, I mean introducing compliance programs, first of all, in your company, ensuring that all employees are aware of competition law. And it's really very important, because when it comes to infringements and applying fines, then typically the fines are applied on the company and not on the person who was directly involved in the infringement, for example, salesperson. So therefore, companies who care about their wallet and finances and the reputation, they also invest in educating their employees. And it means that first of all, introduction of compliance programs, competition law guidelines, if you don't have such yet. Also trainings which are repeated periodically, because people tend to forget things, and also there is usually exchange of people within a company. One employees go, other new employees come, and it means that this cycle has to be renewed. I would also advise to companies, especially in pharmaceutical sector, to check their market shares, because due to patents and exclusivity rights, there might be a higher risk of having dominant position in relevant markets. So check your market share once in a while, and remember that there is this presumption, written or unwritten, 40% and above, which means that if you are there, then at least you should be more careful of your actions on the market and be aware of risks related to dominant companies. And finally, I would say that be aware of other companies' actions on the market, because the tricky part of the competition law is that not only you can be the one who is the bad guy, but you can also be the one who suffers from other companies' actions on the market. So be aware and defend your rights. If you see that some company may be in a dominant position and abuse it over you, or other actions we discussed previously, then consult with your lawyers and potentially go to the competition council and defend your rights for fair competition. And that's my advice.
Thank you, Marika. That's very useful. Now, thank you to all our presenters, to Marika from Latvia, to Lise-Lotte and Olivia from Estonia, and to Erika from Lithuania. we were all lawyers from Sorainen Life Sciences Sector Group, and we were very, very happy to talk to you this morning. And thank you everyone who devoted a few morning hours to listening to us, to ask us questions. And as I said, the presentations will be available, also the recordings will be available. So I wish you a wonderful day and goodbye.